Boker Tov. Good morning. My name is Itai Haas. I'm the head of the legal department at the Official Receiver's Office. It is my pleasure to open the second panel of the day that will deal with financial distress and bankruptcy planning. We'll have 4 speakers today, and if there's still time after the last speaker finishes his speech, we'll open the floor to questions. The first speaker of our panel will be Mrs. Marsha Goldstein. Mrs. Goldstein is a senior partner and the chair of business finance and restructuring department at Weil Gotshal Law Firm. Mrs. Goldstein is representing bank groups, secured and unsecured creditors, and is serving as a lead counsel for various entities at Chapter 9 and Chapter 11 proceedings, among them MBIA, MF Global UK, AAG, and WorldCom. Mrs. Goldstein will speak about bankruptcy remote entities. Ms. Goldstein, please.
Thank you very much. It is a pleasure to be here with you all this morning. I am going to talk about special purpose entities, but in the context of bankruptcy planning. And bankruptcy planning for a corporate entity or a group of corporate entities includes a number of considerations. The type of entity, whether we have a special purpose entity, so-called bankruptcy remote entity, and I'll get into talking about those as one of them. But obviously, the nature of the entity's debt, whether there are actual or impending defaults, cross defaults, the entity's collective and individual liquidity profiles, and whether any particular entity or groups of entities are needed in order to obtain the type of financing that would enable the corporate group to survive through a bankruptcy Chapter 11 proceeding. Obviously, as much time as you have to prepare the case, the more the better, but a study of the company's organizational structure, its documents, various consent rights, restrictions, are all critical. And if you have the luxury of time in preparing for the Chapter 11 case of an enterprise or a group of corporate entities, you might even make changes to the corporate structure that would make your case more effective. Not every entity in a corporate group will need to go through the bankruptcy proceeding. And in fact, I could say the fewer the entities, the better. But sometimes you need to have an entire corporate group in bankruptcy, including entities that might have been viewed as bankruptcy remote. So let's talk a little bit about what is bankruptcy remote, and I apologize that I'm behind on my slides. Special purpose entities typically seek to isolate an asset or a collection of assets from the financial affairs of the special purpose entity's affiliates. And this is done by taking those assets and placing them in the ownership of the special purpose entity, or SPE, and then structurally separating that entity from its affiliates. These entities are used in a number of financing structures. They are used to hold certain real property assets for a very good reason. One, you could reduce the cost of financing. That's a good thing from the borrower's perspective. From the lender's perspective, they would like to have a structure where their collateral, whether it be real estate or something else, would not get entangled in the bankruptcy of the parent or affiliate should that occur. And if you think about it, even from a borrower's perspective, if you're a real estate developer and you're developing a number of projects and you're developing a hotel and you have a condominium project somewhere else, and you have an office building somewhere else, the use of a special purpose entity makes a lot of sense, not only for financing costs, but should one of those entities be over-leveraged or fail for some reason or have liquidity problems, you can work something out with the lender, even if you have to give it back to the lender, and avoid the bankruptcy of the rest of the enterprise. So it's not always the case where the enterprise is going bankrupt and you're holding out the special purpose entity, but from a borrower's perspective, It allows you to carve out the cancer if that is the issue in terms of the financial distress of the company. So from a legal perspective, however, we know, at least in the US certainly, absolute contractual prohibitions against filing for bankruptcy are generally unenforceable as a matter of public policy. But the primary goal of the SPE structure is not to absolutely prohibit the bankruptcy, but to decrease the potential for the bankruptcy filing by the SPE as a result of the situation of its affiliates. So that's why we call them bankruptcy remote, and of course, they are not bankruptcy proof. So in order to isolate the special purpose entity assets, the organizational documents will typically have a number of provisions that are specifically designed to create the separateness. So the SPE would be prohibited from engaging in activities other than owning, operating, or acquiring the specific asset or collection of assets that it was designed to hold. It would be prohibited from significant transactions such as mergers, consolidations, or sales of those assets. Obviously, sometimes there might be a consent provision involving an independent director. Commingling assets would be prohibited. Obviously, cash flows and other revenue generated by these assets should be separated. It would be, and importantly, from a bankruptcy remoteness standpoint, prohibited from incurring any debt or guarantee other than the specific loan or debt that is related to the assets that the company is trying to separate. And of course, it would not be allowed to file for bankruptcy protection without the consent of at least one, sometimes two, independent directors. Now, how those independent directors are selected is, of course, an interesting point, because they will frequently be selected by or on behalf of the lenders, and we'll get into what duties those directors would have. So you'll have at least one independent director on the board of directors. Now, in many instances, the independent director can consider the interests of the lender. Certain corporate forms, and again, going back to what we discussed earlier, state law is very important here in selecting the corporate form, because a New York corporation is going to be different from a Delaware LLC in terms of what you can do in terms of fiduciary duties. So if the corporate documents say that the duty or that the independent director can consider the interests of the lenders, it would be always qualified by the extent that would be permitted by applicable law, and that's going to be state law. So in terms of the process of entering Chapter 11, you need to have an appropriate resolution authorizing the filing from the board of directors. So obviously, the ability of a special purpose entity to file for Chapter 11 is limited by the requirement that one or more of its independent directors approve that decision. Now, under standard corporate law, it's a potential breach of that independent director's fiduciary duty to prevent the bankruptcy filing solely for the purpose of the lender. It must consider the shareholder. Remember, sometimes they can consider the interests of the lenders. It depends on the law applicable to the corporate form and the state law under which the corporate form is organized. But if you look at it from the, I would say, the norm of board of directors' duties, there is a fiduciary duty to the entity and to the shareholder. Now, even if the independent directors approve the filing of a Chapter 11 case for the bankruptcy remote entity, we've seen circumstances where creditors challenge that decision by filing a motion to dismiss the Chapter 11 case. Now remember, the duty didn't run to those creditors necessarily, but they have asserted in cases such as General Growth Properties, which I'll talk about a bit, that a petition was filed in bad faith, alleging that the entity isn't insolvent. Well, we know that solvency isn't a requirement for filing a Chapter 11 case, but there should be some objective in terms of reorganization. And we'll get into that in more detail a little bit further on. Now, a special purpose entity can be subject to an involuntary filing by its creditors. And there is some support in the case law for the notion that an involuntary filing could be a permissible method to circumvent the restrictive provisions in a special purpose entity's organizational documents. But that is qualified by the need for a true restructuring, and an involuntary filing, I won't get into all the details, has a number of requirements, and creditors are wary to file an involuntary filing unless they are not getting paid and there is really a need for the filing. So in that sense, the involuntary is certainly a way to see a special purpose entity filed, but it is not common. Now, another way that a special purpose entity, through its documents, would deter an involuntary filing is through the inclusion in the various documents around the special purpose entity of a so-called bad boy guarantee. And while that is not a primary subject of this talk, I'll just mention it for a minute because it comes up with special purpose entities. So, and I'll use the real estate example again. Real estate developer, condominium project, real estate developer has other projects. In the event that the real estate developer causes a voluntary or participates in any way in causing an involuntary bankruptcy, those of you who litigate a lot would understand that that would become quite the subject of a litigation in terms of causing the involuntary. But in those instances, there would be the trigger of a so-called bad boy guarantee, where the developer entity, whether it's an individual or the developer company, would then be obligated on the debt of the secured lender who financed the special purpose entity. And again, in single purpose real estate projects, or even where a developer has multiple projects, this is a strong deterrent for any kind of bankruptcy and has been used in financing those projects over many years, certainly in the United States. Sometimes they don't work, or sometimes the entities file notwithstanding that because the financial distress is so extreme that the owner, as a board member of the parent corporation, might find it has to vote for a bankruptcy to avoid a breach of fiduciary duties generally. And so that is a problem where these bad boy guarantees are involved in an enterprise of multiple companies rather than in a single project. And again, that's one example of a case that I will talk about where that came up. Now, the next slide, I refer to a concept called substantive consolidation. This is a concept that comes up in U.S. bankruptcy cases and even sometimes involving companies outside of bankruptcy, which is not unique to the situation of a special purpose entity. You could probably spend the half hour talking about cases involving substantive consolidation, but in a nutshell, it's an equitable doctrine. It's developed over many years in U.S. bankruptcy practice, and it's designed to prevent a so-called perceived injustice. In the cases where substantive consolidation is granted, separate legal entities may be disregarded so that the assets and liabilities of such entities would be consolidated and dealt with as if such assets were held by and the liabilities incurred by a single entity. It's a classic, maybe grander version of piercing the corporate veil. So this is an issue that comes up in any enterprise bankruptcy where creditors of one entity see some riches in another entity, and then the question will be raised, and we've seen it raised in negotiations and for strategic purposes in a number of U.S. bankruptcy cases. From the standpoint of the SPE, even if it's not going to avoid being in a bankruptcy case, from the lender standpoint in structuring the financing, and also probably from the borrower's standpoint in this instance, at least you could prevent it from a substantive consolidation by requiring the separateness of it. And so, again, we see in the documentation regarding special purpose entities numerous covenants and provisions that are designed to prevent any findings that match the standards for substantive consolidation. So this slide gives a list of some of the typical items that would be looked at in determining whether a company, whether it be special purpose entity or not, would be subject to substantive consolidation with the assets and liabilities of other affiliates in a Chapter 11 or other bankruptcy case. So, of course, and perhaps most importantly, is the maintenance of separate books and records so that somebody looking at this, you bring in a professional, an accountant can say, you know, there really isn't an issue here because we know what the assets and liabilities of this company is, and they're clearly separate from the other affiliates. But there are a whole list of factors: maintaining separate bank accounts, not commingling assets. Obviously, how do you conduct your business in your name, or are you indicating that you're conducting it in the name of another affiliate? In addition to separate books and records, obviously maintaining separate financial statements. And if there are consolidated financial statements, which there will be, at least on the consolidated financial statements, notation that the assets of this company are not available to satisfy the debts of any other entity. If there's a practice of paying liabilities out of its own funds, and of course observing all corporate formalities of the structure, whether it be a corporate structure, partnership, or limited liability company. And finally, maintaining arm's length relationships with the affiliates. So how does this all play out, particularly in the Chapter 11 case of an enterprise? So the case study, and I know that Professor Adler wanted me to talk about special purpose entities because of all the questions raised about the General Growth case, because he's asked me to do this before. So it's a case that was filed, and this is important, and in April of 2009. It's in the middle of the U.S. financial crisis, and there is no financing available for this company and many other companies in terms of refinancing maturity debts, in terms of bridging liquidity problems. And I raise this because I do believe that the breadth of the filing of General Growth Corporation, which included 300 special purpose entities, each of which owned a shopping mall in the United States, would have looked a lot different if it weren't during a financial crisis. If General Growth had some financial distress because it had 6 bad malls out of 300, there would not have been a mega filing. But when you have an economic situation where there is no financing available and there's a liquidity crisis, you have to look at these companies very differently. So the timing of the filing, very important. April 16th, 2009. 400 direct and indirect subsidiaries of General Growth Properties filed, total of about $30 billion of debt. At this time, General Growth is the second largest owner of shopping malls and one of the largest real estate investment trusts in the United States. And most of their real estate assets, not atypical, were held in separate special purpose entities. And those entities, or 95% of them, filed for bankruptcy along with the corporate parents and holding companies. Now, of course, these entities had independent directors. And you see in the slide that General Growth, in advance of the bankruptcy, removed or replaced the independent directors. Well, why did they do that? They were worried. They had a situation where they had a maturity profile of these entities that was variable. They had some maturities coming up immediately, which they knew they couldn't refinance. But in 2009, even when you looked a year, 2 or 3 years ahead, you didn't have confidence about refinancing. So they all had somewhat different situations. The company had the right under most of the documents to change the independent directors, and they went and interviewed directors who had experience in restructurings, as opposed to typical independent directors of special purpose entities who are, and not to malign them, they come from corporate services who understand the responsibilities of a board member, but not necessarily the experience that this company was looking for. So to the great dismay of parties perhaps in the real estate sector, General Growth removed and replaced most of its independent directors, and given their liquidity issues and their financing issues, they had to take some dramatic actions. So notwithstanding the financial crisis, there was still no understanding on the part of a number of the lenders, and it was mostly servicers of CMBS who moved to dismiss the Chapter 11 cases of their SPE debtors, and argued that the cases were filed in bad faith. Arguments, filings are premature because those debtors were solvent. Remember, Professor McKenzie pointed out, you don't need to be insolvent to file. And they argued that the filings were only for the benefit of the distressed parent entities and not the SPE debtors. They argued that these cases were futile because no plan could be confirmed over the SPE debtors, lenders' opposition. It's very hard to cram down when you only have one secured lender. You need an impaired accepting class. And in some of these instances, there were also mezzanine level debt at the property levels. So it would have been difficult, but not necessarily impossible to have a confirmable plan. Finally, they argued, and I thought this was perhaps their weakest argument, that there'd been a failure to negotiate with those lenders before the filing and before removing the independent directors. But of course, those of you who have experience with CMBS know that the servicers don't engage in negotiation. There have to be defaults. There have to be special servicers. And while we sent a communication to all of the servicers inviting them to a meeting, nobody showed up. So the argument that there were no negotiations did not hold up from a factual, or at least there was an attempt at negotiations. So what was important here is that the bankruptcy court denied the motions to dismiss, but at the same time examined the situation of special purpose entities, so-called bankruptcy remote entities, filing for bankruptcy. And the bankruptcy court found that they were in varying degrees of financial distress at the time of the filing, and spoke of the collapse of the CMBS market, and that left the special purpose entity debtors without a clear path to refinancing, and that the debt was scheduled to come due in the next several years. And when you look at General Growth and the end result, which was payment in full for all creditors and equity remaining for the public shareholders, this was an example, which I think would be a rare example because of the circumstances, where the financial conditions in the economy threatened to impair inherent value. And by enabling these companies to file as an enterprise and obtain financing in the bankruptcy and obtain a way to negotiate a better maturity schedule, tremendous value was protected and preserved for the benefit of all of the stakeholders. This could have collapsed if those special purpose entities cases were dismissed. But instead, there was a framework provided to renegotiate all the mortgage debt and to provide a maturity schedule that was put out into the future, low rates were maintained, and suddenly the corporate entities became very valuable. It was, in my view, the right use of Chapter 11 in a time and place. And so the bankruptcy court understood this. The value hadn't been proven at this time, but certainly understood, and this is the need for some flexibility in terms of bankruptcy judges and how they view our cases. The decisions to file for bankruptcy by the SPE boards of directors were found to be made after numerous and detailed board meetings considering the financial condition of each of those entities. And so it was appropriate not only for those boards to consider the interests of the individual entities, but also the enterprise when they were filing the special purpose entities. So the court also rejected, and this has occurred in non-SPE cases as well, the notion that a case should be dismissed because the secured creditor says you can never file a plan. Never is a strong word. Negotiations can ensue, and so the court obviously did not buy that argument. And from the standpoint of subjective bad faith, the court recognized that the efforts to negotiate with these secured lenders pre-petition would have been futile. So the court found no subjective bad faith. So just to summarize some of those implications, and I know my time, I think, is up, the fears that a case like General Growth, where special purpose entities are collectively put into bankruptcy to support an enterprise, Chapter 11, were probably overplayed at the time. I would say that the result is there's some tightening of provisions in financings, particularly on removing and replacing independent directors, a lot more focus on looking at the interest of the secured lender. But outside of putting some focus on that documentation, I can't say that this case changed how we structure bankruptcy remote entities. They still have usefulness in terms of bankruptcy planning, in terms of financing, and I think that it's a structure that we're going to live with as an ongoing matter. There are a couple of other cases in the material that are on the website, and I welcome you to look at them as examples of how an entity that is structured not to be in bankruptcy can be successfully reorganized in bankruptcy. Thank you.
Thank you, Mrs. Goldstein. Our next speaker will be Professor Barry Adler. Professor Adler is the Bernard Patry Professor in Law and Business, as well as Associate Dean for Information Service and Technology, and has recently completed a term as Vice Dean at NYU School of Law. Professor Adler advises on corporate and insolvencies issues and serves as an expert witness or consultant on that matters. Professor Adler has published numerous articles on the application of corporate finance theory to issues of corporate insolvency. Professor Adler will speak about the timing of filing and firm value. Professor Adler, please.
Thank you, and I also want to thank David for inviting me and for putting this conference together. I think it's an excellent idea, and I'm honored to be here. Excuse me. So Marsha talked about both planning for bankruptcy and avoiding bankruptcy. The General Growth case, there was an attempt to avoid and then planning to get the firm successfully through the bankruptcy despite the avoidance. I'm going to pick up on that theme a bit and talk about avoidance, but of a more ordinary variety, of simply delay and putting off the day of reckoning longer than might otherwise occur. Delay is in itself a form of avoidance and is related, obviously, to bankruptcy planning, because if the idea is that bankruptcy is to be avoided, that itself is a plan of sorts, and I'll talk about that in a little more detail. I don't have slides today, but I posted an article that I wrote with two co-authors, Bedrin Kapkin and Larry Weiss, and my comments today are based on that article, so that's available to all of you as well. So Troy earlier mentioned a change in bankruptcy practice that has occurred recently. Prior to the 1990s, when a firm entered bankruptcy voluntarily, which was the typical case for a corporate firm, particularly for large firms, they entered bankruptcy under the control of the management that was at the helm prior to the financial distress, and the management, as the debtor in possession, took the firms through the bankruptcy process. And as I say, prior to the 90s, that was the standard practice. Things began to change, though, in the 90s. Until today, it is quite common for a firm to enter bankruptcy under the control of a secured creditor. So when the firm enters bankruptcy case, although management is still in control, that management itself is a agent, if you like, of a secured creditor who has insisted on such control as a condition for the secured lending that occurred often very recently prior to the bankruptcy petition. So in the literature and the debate over this process, the sea change between the 90s and today has been referred to as a switch from debtor in possession to secured creditor in possession. And this is commonly discussed and is a well-known phenomenon. So what my co-authors and I did is to look back a bit, say, okay, we know that the secured creditors are very often in control of a firm at the time it files for bankruptcy, but what are the implications of that switch? Or to put it slightly differently, how did we get here? Why did the switch occur? And we looked at those questions trying to answer them simultaneously. So we observed the effect of the results in bankruptcy cases that may have preceded this shift of control from the debtor in possession to the secured creditor in possession. And we noted, and again, this was widely observed, that bankruptcy had resulted in a harder landing for management and equity than in the past. So as time went on from the 90s through the beginning of this century, managers were more often than previously losing their jobs in bankruptcy. They always lost their jobs at some level of probability, but that probability became higher. And equity, the common shareholders, who used to get a small return despite the failure of the firm to pay the creditors in full, were routinely getting wiped out entirely. So bankruptcy was less and less a friendly place for the managers or their principals, the shareholders. And one might predict that as a result of this hard landing, managers would try to delay the bankruptcy. So instead of planning for the bankruptcy case, instead of trying to file a case when financial distress became serious, the form of planning that took place was, as I mentioned earlier, a plan of avoidance. Let's not plan how to conduct the bankruptcy case. Let's plan how to avoid the bankruptcy case. So this was at least a hypothesis. This is what we assumed the managers were doing. Well, how would they manage to avoid the bankruptcy case? Well, one way is simply to not file. So in the American system, creditors cannot force a debtor into bankruptcy unless the debtor is not paying debts as they became due. So unless a large portion of the debt is matured, a debtor can simply not file for bankruptcy, can choose not to enter bankruptcy by paying the debts that's maturing and simply staying mum and doing nothing with respect to the unmatured debt, even if the firm is deeply insolvent. This is perceived as a problem. It's always been perceived as a problem. But now that managers dislike bankruptcy, our hypothesis said this problem was exacerbated, we imagined. What would the managers be able to do now? What the managers would be able to do now, we hypothesized, was borrow more extensively in times of financial distress than they did previously. Previously, we imagined, if financial distress was reasonably serious, they would, at least relatively more often, file a voluntary bankruptcy petition and have the debtor reorganized at that time. Now, at that same moment in their financial decline, they would borrow more. They would borrow from secured creditors who would attach the strings that I spoke about earlier. What the secured creditors will do is say, look, you're in pretty bad shape. If you have unencumbered assets, though, we will lend to you, but we're going to hold the reins. You're going to either pay us back, or we're going to exercise our control and our security interest and the documents, the agreements that we'll get connected to those security interests, and we will take over the firm and we will bring it into bankruptcy and we will run the bankruptcy for our benefit, not anyone else's. In the past, that deal was unpalatable, we hypothesized to the managers, who said, well, we won't do that. Instead, we'll go into bankruptcy and take our chances with a restructuring. But now, this previously unpalatable deal may have been the only choice. Well, as I say, that's our hypothesis. And so the question is, how do we test it? If the hypothesis is true, we should have observed that firms, at the time they filed for bankruptcy in the modern era, or more recently, would be in worse shape than firms that filed for bankruptcy in the prior era or in the more distant past. So that's what we looked for. We looked at financial ratios and economic asset values for firms at the time they filed for bankruptcy. And sure enough, our hypothesis was confirmed. Firms that file for bankruptcy now are more leveraged, they have heavier debt than in the past. They have more secure debt than in the past. And significantly, they have less value than in the past. Their assets are less valuable. They have suffered operating losses for a greater period of time than firms that filed for bankruptcy at that time in the past. This is an economic problem. In the finance literature, or in finance theory, I should say, if the only effect of a change in practice or of law is to change the allocation of resources without changing the total value of those resources, this isn't by itself a problem. We expect financial actors going into the world of changed allocations to adjust their contracts accordingly. And although they might be winners and losers, while there might seemingly be winners and losers ex post, the fact that in anticipation of these results they could contract to protect themselves, there would be no economic loss from such a change in allocation. So the fact that firms were going into bankruptcy more leveraged than in the past was not itself troubling. What is troubling, though, is that they're going into bankruptcy suffering economically, more so now than in the past. That firms, when they file for bankruptcy now, have assets of lower value, that there is greater waste through this process as I just described. To be sure, though, that this was happening, we did some robustness checks. We compared bankrupt firms to non-bankrupt firms. We controlled for interest rates, and the robustness held up. That is, no matter how we looked at it, no matter what we tried to control for, we found that firms were entering bankruptcy these days as compared to the past in greater financial distress, and again, significantly with a lower asset value, with greater losses, greater operating losses over time. So, what to do about this? One thing that one might think of as a policy matter is if the problem of the hard landing is causing these negative consequences, we might soften the landing. We might go back to the day when firms could file for bankruptcy, where managers would have a chance of keeping their jobs, where equity would get some share of the firm, even if the creditors are not paid in full. And this might encourage a quicker reorganization than we're currently seeing, and less decline into distress prior to a bankruptcy filing. Well, this struck us as not a very good recommendation, because there was a reason the landing became harder. Creditors weren't happy with having to pay managers of a failed firm for their cooperation in the bankruptcy process. They didn't want to keep the managers on necessarily. They didn't want to have to share with equity a portion of the firm. And perhaps more significantly than the amount that was paid to equity was when equity maintained control of the bankruptcy process in service of trying to win this small concession to equity. There may have been significant delays and costs of running the firm during the bankruptcy process while the negotiation for equity's small share took place. There would be deadweight loss. So it doesn't seem like a particularly good prescription to go back to the time. The soft landing had its own problems. Moreover, as other scholarship has shown, if managers in equity anticipate a soft landing in the bankruptcy case, they may fear it less and behave in ways that are less efficient for the firm so that losses and bankruptcy become more common. So the soft landing, for all these reasons, doesn't seem to be a good solution. Perhaps the current solution, despite the trends that we identified, is the best possible world, and maybe nothing should change. But that was not our recommendation either. So there's another approach that could be taken, and this is a radical approach, or at least it would be radical in the US. I don't think it's going to be adopted, but for this audience, I want to throw it out there because it might be something to consider as one is trying to balance its own bankruptcy system, creating new laws or regulations. Maybe it wouldn't be so radical here, I don't know. The source of the problem, as we've identified it, is that the secured lenders on the eve of the bankruptcy case, I'm sorry, not on the eve of the bankruptcy case, the secured lenders on what turns out to be the eve of a bankruptcy case, the secured lenders at a time when a firm is distressed, are financing ruinous continuation because their security, their high priority, is protecting themselves against the ruin, which is then visited upon the unsecured creditors. A way to stop this counterproductive continuation, if that's what it is to lower the priority of those late secured lenders. That is, deny them their security, or at least to some degree deny them their security, or to reduce their security to account for the fact that what they're doing by lending to an insolvent firm in order to pay off some, but not all, unsecured debt is financing financial destruction. There are various methods of doing this, and given the time we have, I can't go into them in detail. But something along the lines of telling a lender to an insolvent firm that it cannot take priority higher than the priority of the debt that is being repaid with the loan would stop this problem in its tracks. It would force firms into bankruptcy sooner rather than later, and it would do so without upsetting the priority of giving the firm to the creditors until they're paid in full ahead of equity, which is the financial deal. This might be productive. It might not be, but it might be productive, and our evidence anyway suggests that it's something worth trying. And in conclusion, I would just say that one thing academics perhaps bring to an analysis of how the bankruptcy law might work is a disregard for the real world, and this has all sorts of negative implications. But it might have some positive implications as well, particularly in a system that is reinventing itself, as the Israeli system may be, and it may thus just be something to consider. Now, Judge Glenn is going to talk about the fiduciary, among other things, about the fiduciary duty of managers and directors when a firm is in the zone of insolvency. I've tried to give you a little bit of an empirical basis of what they actually do as opposed to what their duties might say. So I hope at least the empirical side of this work introduces some of the real world as well. So that said, I'm out of time in 14 seconds, and so I'll leave it at that. Thank you.
Thank you, Professor Adler. Our next speaker is Honorable Martin Glenn. Honorable Glenn serves as a United States bankruptcy judge for the Southern District of New York since 2006. Honorable Glenn is a member of the National Conference of Bankruptcy Judges and is a contributing author of the Coolio on Bankruptcy. Judge Glenn is a frequent lecturer on bankruptcy-related issues and will now speak about fiduciary duties of the board upon financial distress.
Thank you. First, let me say it's a pleasure to be here. And what I'm going to try and talk about really are things that happened before bankruptcy, but may arise in a bankruptcy case, and that's the issue of fiduciary duties of the board upon the financial distress of a company. And Barry Adler spoke about the timing of filing, and it's the dilemma, when to file for bankruptcy. So what happens, one of the things that I think actually, as I understand your law in Israel, it's similar to ours in the United States, and that is that a company that's insolvent may continue to operate. And that's not true all over the world. In Europe, for example, in many of the countries, it's actually a criminal violation for directors to continue to trade after the company's insolvent. It can lead to some fairly odd results, and much of the structure of insolvency in Europe is liquidation. So there's a lot at stake about determining what's that point of insolvency, when do the directors have to commence an insolvency proceeding. At that point, they're basically out of their jobs, and the company is going to be liquidated. So in the United States, that's not true. And as I understand the situation in Israel, it's not true here either. So in the United States, directors can continue to try and rescue the company from insolvency or generate more value before a company is liquidated, if it's liquidated. And what I'm going to talk about in large measure are two cases in particular. And I think that David Hahn spoke about one of the things about the United States that's different from the situation in Israel is that state law, the law of the 50 states and the District of Columbia, plays an important role. All property rights in the United States are determined by state law, not by the federal bankruptcy code. All right. So what we as bankruptcy judges do, we look to federal law, the bankruptcy code, and it in many respects provides the procedural overlay for what we do. But in determining what are the rights, the property rights of a company, that's state law. And a thing like a breach of fiduciary duty claim, that's a cause of action and it's determined by state law. So state law controls. So I'm not going to cover the law of 50 states, but what I am going to talk about principally is the law in the state of Delaware. Delaware has been, for a long time, the preeminent state court jurisdiction for determining the obligations and the responsibilities of a corporation and its board of directors. There are differences in the law in states. I'm going to point out a few of them along the way, but I'm mostly going to focus on what's Delaware law. All right. And there are two key cases that I'm going to talk about. One is the decision of the Chancery Court, which is the trial court level for corporate law matters, and it's a case called Trenwick. And they're not there yet, but I'm going to post the two decisions that I'm going to talk about. The Trenwick decision from the Chancery Court. It happens that the author of that decision has now been nominated to be the Chief Justice of the Delaware Supreme Court. And the Trenwick decision, even though it was the trial court decision, it was affirmed by the Delaware Supreme Court on the basis of the opinion of the trial court. All right. Excuse me. And in Trenwick, the court found that Delaware law imposes no absolute obligation on the board that's unable to pay its bills to liquidate. Even if the company is insolvent, the board may pursue, in good faith, and that's an important qualifier, strategies to maximize value of the company. All right, so when is a company insolvent? Determining insolvency is a very difficult issue. It can depend very much on the facts and circumstances. There are a number of different tests that are applied for determining insolvency. The Bankruptcy Code has some alternative tests for determining insolvency. State law, because it's relevant to issues like fraudulent conveyance claims, has different tests for insolvencies. But one of the most customary ones is to determine whether the value of the liabilities exceed the reasonable value of the assets. Now, that leaves a lot of ground for what's the measure of determining value of assets, what do you do with things like contingent liabilities, how do you determine how those should be valued for determining insolvency. And I can't resolve any of that or give you much guidance on that, just to say that determining that point of insolvency is very difficult. All right. So another court has determined the inability to pay your liabilities when they become due, or no reasonable prospect to be able to avoid a deficiency. Those are all tests. So at the bottom of this slide, you see the reference to the second case that's really quite important, the Jiwala case. And it's a decision by the Delaware Supreme Court in 2007. It remains, I think, controlling law and the leading decision on issues of fiduciary duty of boards of directors in cases where the company is what's referred to as in the zone of insolvency or insolvent. What's the zone of insolvency? Because it's so hard to determine when a company is insolvent, is it's near insolvency. And how would one determine that? And what are the consequences? And I'm going to talk about what the consequences are. All right. So what's the director's obligations when you're near insolvency but not yet insolvent? All right. And what that Delaware Supreme Court G. Wallace said, when operating in the zone of insolvency, directors still must exercise business judgment in the best interest of the company for the benefit of its shareholder owners. And the important statement there is for the shareholder owners, because one of the issues about zone of insolvency is, do the directors, when the company is operating near insolvency, do they owe their fiduciary duty to the creditors or to the company and the shareholders? And there are states where this so-called concept of zone of insolvency is accepted, and the result is that when you're operating in the zone of insolvency, the director's responsibility, at least in part, shifts to protecting creditors. And what the Delaware Supreme Court said in Jiwala, not so. The obligation, when you're in the zone of insolvency, remains to the company and to the shareholders. So what are the shareholders when it's in the zone of insolvency? What Delaware focused on is the economic concept of who are the residual owners of the company. And as long as a company remains solvent, even if it's close to insolvency, the residual owners remain the shareholders, not the creditors. All right. So Delaware law says if you're in the zone of insolvency, the director's obligation still, acting in good faith, is to act for the benefit of the company and its shareholders. There's no fiduciary duty owed to its creditors. And the directors must comply with their fiduciary duties. They can pursue plausible and prudent strategies to maximize the firm's value. All right. And the business judgment concept, I don't have a separate slide on it, but important to the fiduciary duty of directors is the so-called business judgment rule. Directors are protected as long as they act in good faith in what they believe to be the best interests of the company. And Delaware corporate law specifically provides that a company's charter can provide protection for directors against liability for breach of duty of care, even for simple negligence. That gross negligence or something more than that is required to establish liability for corporate directors. All right. So directors have to comply with their fiduciary duties. They can pursue plausible and prudent strategies. For companies in the zone of insolvency, it's still, the directors are protected if they act in good faith in the best interests of the company. And why is it important? What the Jiwala case said, it's important because directors have to have the ability to negotiate with creditors in good faith. So much happens outside of the bankruptcy court today with efforts at restructuring outside of bankruptcy. Can the directors negotiate with the creditors without facing liability for breach of fiduciary duty? If there was a duty owed to the creditors, that would be more difficult. All right. So what are the director's obligations during during insolvency? Now, if you can determine when that is, what happens when the company is insolvent? So when a firm is insolvent, the directors, the residual owners, become the creditors, in effect. The value of the equity is no longer there when it's insolvent. And so there is a fiduciary duty to correct creditors. But the directors continue to operate to maximize the economic value of the firm. That's important. Continue to operate to maximize the value of the firm. You don't have to file a bankruptcy proceeding. All right. And insolvency does not suddenly turn the directors into mere collection agents to collect money for the creditors. Directors of insolvent companies must retain the freedom to engage in good faith negotiations with individual creditors for the benefit of the corporation. All right, so what are the risks that directors in companies when they're in the zone of insolvency, what do they face, or during insolvency? So there is potential liability for conduct, and outside of bankruptcy, we have in our law in the United States so-called derivative actions, where shareholders, or in this case it would be creditors, acting for or on behalf of the company, not for their individual liability, can bring an action against directors, a so-called derivative action. And so if a company is insolvent outside of bankruptcy, yes, the creditors can bring a derivative action against the directors, alleging breach of fiduciary duty, for example. All right. There's also potential liability for fraudulent transfer claims, for breach of contractual covenant claims. We'll talk more specifically about that in a few minutes. And I'm going to talk about, there's a doctrine now rejected in Delaware and in many other jurisdictions about deepening insolvency. And what Barry talked about is, where you delay filing for bankruptcy and increase the debt. And if the company doesn't turn itself around, the likely recovery to creditors is actually diminished because the size of the creditor pool has now increased. And is there liability for directors for this so-called deepening insolvency? All right. And there's a split in authority. It's recognized in some jurisdictions and not in others. Ordinarily, the breach of fiduciary duty claims are available where this independent cause of action for deepening insolvency is not recognized. And Delaware has specifically rejected it. And Delaware has said there's no special duties to creditors owed during the zone of insolvency. And even when a company is operating in the zone of insolvency, the director's fiduciary duties are owed to the company and shareholders. We talked about that. And here, this is the theory behind it, is that before insolvency, imposing a fiduciary duty to creditors would distort the incentive structure for corporate managers and ensure that a company that remains in the zone of insolvency, to avoid litigation costs, they act not necessarily in the best interest of the company and all creditors. So unless the company is insolvent, directors should undertake business activities for the benefit of the residual risk bearers, and that's the owner of the equity. Creating a special duty would make it much more difficult to recruit qualified directors. They'd be second-guessed, the fear of being second-guessed for everything they do would be a problem. All right. So, but one of the things what Jiwala and Trenwick point to is, while there's no special fiduciary duty to creditors, the creditors have a way of protecting themselves, and that's first through covenants, their contractual provisions, lien on assets, secured credit. There's fraudulent conveyance law, and I'm going to talk more about that. There are causes of actions for fraud generally. Those are a way that creditors can protect themselves without imposing a fiduciary duty by directors on them. There's also implied covenant of good faith and fair dealing in contractual relations. The bankruptcy law can provide some protection, and general commercial law provides protection. All right. So recognizing a duty, what Delaware court has said is if you recognize this duty in the zone of insolvency, it would fill gaps that don't exist. When it said don't exist is because contract law, secured creditors law, general commercial law, good faith and fair dealing, those already operate to protect creditors when they're in the zone of insolvency. All right. And creditors, and here's what the courts have said, creditors are presumed to be able to protect themselves through contractual agreements, and they don't need this special protection. Now, in some jurisdictions, coming back to the deepening insolvency theory, what Barry talked about the actual experience and what his study has shown is that many companies have actually increased the degree of their insolvency while they continue to operate by taking on additional debt, undertaking risky transactions that may be sort of the last gasp hope of creating value for equity. And some jurisdictions do recognize it. In the United States, in the federal court system, we divide our country into circuits. The Third Circuit is Delaware, Pennsylvania, and maybe and a couple other jurisdictions. And the Third Circuit, applying Pennsylvania law, has found that Pennsylvania would recognize this deepening insolvency theory. As I say, Delaware has rejected it, and I think many other jurisdictions have as well. All right. And what the Delaware said is that with the prospect of profit often comes the potential for defeat. And if a director has acted in good faith, you shouldn't punish them for having done so. The directors are not guarantors of success. All right. Delaware, again, found the separate tort of deepening insolvency unnecessary. And the court found no difference between deepening insolvency and lessening profitability, which is not a tort, absent a violation of fiduciary duty. Other courts have followed the Delaware courts. So fraudulent conveyance law, and I know you have fraudulent conveyance law here in Israel as well. And in the United States, we look at two regimes. The Bankruptcy Code itself, in Section 548, recognizes both claims for actual fraudulent conveyance and for constructive fraudulent conveyance. It's Section 548 of the Bankruptcy Code. Section 544 of the Bankruptcy Code also allows a trustee or a debtor in possession to take advantage of state law. So our state law has, many of the states have fraudulent conveyance law as well. All right? And both of those can operate in bankruptcy. One of the big differences is that with the Bankruptcy Code, the look-back period, the statute of limitations is limited to 2 years. In New York, the statute of limitations on fraudulent conveyance is 6 years. It varies from state to state. In some states it's 4 years, some states 3 years, but usually longer than the 2 years. So a trustee, for example, or a debtor in possession, or a creditors committee that gets the right to sue on behalf of the estate can often go after transactions that occurred much longer ago by applying state law. All right. So fraudulent conveyance allows setting aside or recovery where transfers were made or obligations incurred, either actual fraud or constructive fraud. And in bankruptcy cases, fraudulent transfer, as I said, is brought under 548. 544, as I've mentioned, enables the estate to take advantage of state fraudulent conveyance law. And what it generally requires is, at the time of the transfer, the transferor, the company that made the transfer, was suffering from one or more statutorily defined forms of distress, either actual fraud, and how do you show fraud? It's hinder, delay, or defraud creditors. It was a transfer made for the purpose of hindering, delaying, or defrauding any one of those three. Constructive fraud requires that at the time of the transfer, the transferor, the company that made the transfer, did not receive reasonably equivalent value, which can be difficult to determine. And at the time of the transfer, the company was suffering from financial distress. Either it was unable to pay its debts as they matured. And one of the things we look at with actual fraud, there are so-called, I'll go over this quickly for purposes of saving time, there are so-called badges of fraud that the statute provides or the case law provides that you can look at to determine whether there's fraud that's existed. All right, so the badges of fraud, there's lack of adequate consideration. Given the difficulty of proving, we look at the badges of fraud, the close relationship between the parties, retention of possession of benefit or use of property, look at the financial condition of the transferor before or after the transaction, that it was a transaction that worsened the company's financial condition, that one looks carefully at the chronology of events. Was it a transfer of substantially all of the property? Was the debtor rendered insolvent by the transfer? Did it have inadequate capital to continue to operate its business after the transfer? Most states apply we have a number of uniform laws in the United States. They're not effective unless they're adopted by specific states, but one of the uniform statutes is the Uniform Fraudulent Transfer Act. Many states have adopted it. It sets out many of these criteria for determining fraudulent conveyance. New York actually applies an earlier version of a statute that has some differences, but it's mostly the same. Again, is it a transaction intended to hinder, delay, or defraud? Was it, again, I won't go through each of these. This is somewhat repetitive. You'll be able to see it on the slides. So one of the things that we see more and more in bankruptcy, where a company is distressed, has good businesses and maybe bad businesses, is an effort as part of the out-of-court restructuring process to separate the good assets from the bad assets. And that can lead to problems under fraudulent conveyance. So one of our colleagues in the Southern District of New York, Judge Alan Gropper, in a recent case, in the Tronics case, he determined where Tronics split off its good assets from its bad assets, he found first he applied something called the collapsing doctrine. Because these transactions that were done happened over a period of years in separate transactions, there's a doctrine that allows a court, under certain circumstances, to collapse them all together and look at them as one, and look at the actual impact on all of them together. And he found that it involved a transfer for less than adequate consideration at a time that the debtor was insolvent. It wasn't a debtor yet in bankruptcy, but the company was insolvent. The result, he still has to determine the amount of damages. He rendered a very lengthy decision a few weeks ago. But the range of damages that have been estimated in the Tronics case are somewhere at the low of $800 million up to $14 billion. So we see this fairly frequently now, where as part of a restructuring process, people will try and separate the good assets and bad assets into separate companies, but fraudulent conveyance law would still apply. What Judge Gropper in Tronics did, he said the collapsing doctrine applied. Yes, many of the transactions happened outside of the 2-year period covered by the bankruptcy code, but within the longer statute of limitations provided by state law. And he determined that this restructuring out of court actually involved a fraudulent conveyance. I'm going to try and combine some of these things now. All right. Reasonably equivalent value, again, like any valuation, can be very difficult to do. And what courts have talked about, and the old Carco is actually the Chrysler case. In the bankruptcy court, it was one of Judge Gonzalez's cases. The decision I'm referring to on the screen is actually from the Second Circuit. And ordinarily, appeals from bankruptcy court in the United States go first to the district court and then to the Court of Appeals. There are circumstances in the code that allow for an immediate appeal to the Court of Appeals with the certification by the bankruptcy court and permission from the Court of Appeals. And in Chrysler, which all happened very, very quickly, Judge Gonzalez had certified it for immediate appeal. The Second Circuit took it and affirmed Judge Gonzalez. So one of the things you look at was, are there significant disparities between the value received and the obligations assumed? And will it significantly harm creditors? And it's a very fact-specific question, which can be very difficult to determine. The court can consider the direct and indirect benefits of the transaction, so long as indirect benefits are concrete and quantifiable. Courts look to the value at the time of the transaction. Courts consider whether value of what was transferred is equal to the value of what was received, the market value of what was transferred and received, whether the transaction took place at arm's length. Did the transferee act in good faith? The transferee is the one who receives the assets. All right, and I refer to the Tronics case where the defendant spun off a business with $550 million of debt, substantial environmental liabilities, and environmental liabilities, cleanup costs, are largely a contingent liability because you don't know exactly what they are. They're very difficult to value. And the company had $40 million in cash at the time. But the defendants were quite clear about what the purpose of the spinoff was, to try and create this good company and bad company. But even where the defendant's motives are known to the creditors, the court may find a fraudulent conveyance if the debtor intended to hinder, delay, or defraud its creditors. And the court in Tronics rejected the idea that defendants were merely managing liabilities. The defendants left the liabilities attached to a fraction of the assets. All right. And that sort of takes me through where we won't do questions now. I know that we'll move on from here. Okay? Thanks very much.
Thank you, Judge Glenn. Our last speaker is Mr. Jay Goffman. Mr. Goffman is a senior partner and leading the corporate restructuring group at Skadden Arps law firm. Mr. Goffman is considered an innovative and creative lawyer leading out-of-court restructuring and prepackers, such as the MGM prepackage. Mr. Goffman will speak about bankruptcy as a means to creating consensus.
Well, first of all, good morning. It's a pleasure to be here. It's an honor to be in Israel. It's a pleasure to be part of this distinguished panel. I'd like to thank David Hahn for organizing the conference and for inviting me to participate. As said, today I'm going to be speaking about the philosophy of restructuring. Specifically, I'm going to be talking about the evolution over the last 35 years of restructuring moving more towards a consensus building and deal-making philosophy as opposed to a litigation or a more adversarial system, which I think we had before. But I think it's fair to say that this evolution over the last 35 years has tremendously benefited those companies that have restructured in the U.S. But it's also important to companies that operate worldwide because they have the ability in some cases to take advantage of the Chapter 11 process, and hopefully the technology that we've developed in the U.S. can be exported around the world. To understand the evolution of the United States bankruptcy law towards this focus on consensus, I think you have to go back and think about how the law developed over the last 35 years. Prior to '78, bankruptcy in the United States was less company-friendly, I think it's fair to say. Reorganizations were often long, drawn out, and litigation-oriented. Liquidations were not uncommon. And in '78, Congress passed the Bankruptcy Reform Act. Now, the Bankruptcy Reform Act included new Chapter 11, and this, for the first time, focused the power of bankruptcy law on reorganizing and rehabilitating businesses, as opposed to liquidating businesses for the benefit of senior secured creditors. Now, in understanding the rules that we're going to talk about, it's important to keep in mind two of the principal goals of restructuring. The first is obviously to reorganize businesses, which will maximize preservation of jobs and maximize value for the business and the country. And the second is maximizing the value of the business for the benefit of the stakeholders. Now, we're going to talk about the rules and the powers that are inside of Chapter 11 and how that works towards building consensus. Before I do that, though, I would like to step back for a moment and acknowledge someone that's here, someone who is the dean of the bankruptcy community in the U.S. and probably worldwide, and who was the driving force behind the enactment of the Bankruptcy Code, Harvey Miller. So Harvey, all of us that practice in the area of restructuring owe you a great deal of gratitude. Now, Chapter 11 was revolutionary. It provided brand new tools that debtors could use in restructuring. Now, some of these tools we've talked about already. Importantly, it included the concept that management will stay in place and continue to operate in the ordinary course of business. No trustee or receiver had to be appointed. And this was very important because it encouraged companies to actually file earlier. Second, it gave the debtor the exclusive right to file a plan of reorganization for at least the first 120 days of the case, and very often this was extended for extensive periods of time. Third, we talked about the automatic stay. The automatic stay goes into place immediately upon the filing of a Chapter 11 petition, and it prevents all actions against the debtors, with certain limited exceptions, from moving forward. And that's designed to give the debtor breathing room to begin the process of reorganization. Fourth, we have the ability to assume, reject, or assume and assign executory contracts, regardless of whether or not the counterparty to those contracts agrees. We have DIP financing, which is the ability to acquire new financing or loans on favorable terms, including by priming existing liens, subject to concepts of adequate protection. Next, we have the ability to sell assets free and clear of liabilities under Section 363. And then maybe we have the most important concepts, I think, in Chapter 11, which are the voting and binding powers of Chapter 11. Now, we talked about this earlier. In Chapter 11, you divide your creditors and equity holders into various classes, and then they vote on the plan of reorganization by class. In order for a class to accept of creditors, you need 2/3 in amount and more than half in number, counting only those parties in that class that actually vote to vote in favor of it. If you get that type of majority to vote in favor, then that vote is binding on the rest of the class, regardless of whether they voted for or against or just abstained. That's a very important power. There are certain other basic tests you have to meet, but that's a very important power. And then finally, it's the cram-down provisions. So when you have a class that actually votes against a Chapter 11 process plan, you can still cram it down over their objection as long as you meet a couple of basic tests, unfair discrimination and the fair and equitable test. Together, these rules, these powers that I just described, really gave us the building blocks to be able to to build a consensus that will lead to restructuring of many businesses. Now, I remember the early 1980s was a very exciting time. Those of us that were fortunate enough to practice in that time were just at the beginning, right after the Bankruptcy Code had been enacted, and we got to develop these new tools together. There were a record number of bankruptcies that were filed during those times. They were larger. And there's no question that the provisions of Chapter 11 created greater opportunities for reorganizing those businesses. But many of us that were practicing at that time thought that we could still do it better than we were at that early period. There was still an awful lot of litigation. Cases were taking a significant number of years. They were very adversarial. And many of us thought that if we could get to a more deal-oriented, a more consensus-building approach, we'd be able to restructure more businesses quicker, more efficiently, and more cost-effectively, and in the process, damage those businesses a lot less. Now, you have to remember, back in the early days, at least for me, it was 30-plus years ago, when companies would have distress, they wouldn't call their restructuring lawyers early. They would wait to the last second. There was still a stigma attached to the concept of filing. They would call you at the last second. They were basically out of cash, and you didn't have much of a choice but to prepare for and file a Chapter 11 process. And you'd begin that lengthy multi-year process of litigating towards a restructuring. Now, I think, in my view, one of the principal developments and evolutions over the last 30 years was what began in the late 1980s and early 1990s, which is the concept of pre-packs. Now, we've talked a little bit about pre-packs already, but pre-packs are a very simple concept when you think about it. The idea of a pre-pack is simply where you negotiate, you reach a consent, before you ever file for Chapter 11, you negotiate the entire terms of the restructuring with your principal creditors. You document it in a plan of reorganization, you send it out for a vote, and when you have that vote in hand, only when you have the vote in hand, do you file for Chapter 11. And the reason you file for Chapter 11 is what I talked about earlier. It's the binding provisions of Chapter 11 and the voting process and the ability to cram down in certain circumstances. So the idea is you develop that consensus, you then file for Chapter 11, and in a very short process, usually 30 days or less, and in at least one case, at least done in one day, you can get a company through an entire Chapter 11 process and make it binding on the holdouts and those parties that would otherwise object. This obviously makes it quicker, it makes it less expensive, it's more efficient, and it's less value destructive to a company. No matter what we in the United States think about Chapter 11, we think it's a good thing, we recognize that for a lot of multinational businesses, especially, the concept of being in a traditional free-for-all Chapter 11 is foreign in many other countries and can lead to runs on trade credit and damage to the business. So let me talk about a few recent examples. Did I miss one? No, you have 10 minutes more. Oh, good. I have more time. Thank you. Let me talk about a few recent examples of consensus-building type presentations that we've done. Recently, we did a pre-pack for a company called CEDC, Central European Distribution Company. It's a company that's headquartered in Poland and in Russia. Principal operations were in Poland, Russia, Hungary, and the Ukraine. When you study it, you figure out pretty quickly those are pretty unfriendly laws when it comes to restructuring. Basically, when we looked at it, we realized that if you actually had to file for restructuring those companies, those were liquidations. And they'd be quick liquidations. There was no concept of reorganization. We also had the problem that in those countries, as has been mentioned, there's not the possibility of continuing to operate while you're insolvent. You had to file. If you're insolvent, you have to file, or the directors face the possibility, real possibility, of civil or criminal prosecution. So what did we do there? We looked at this business that basically operated in Russia, Poland, Hungary, and the Ukraine and said, we're going to do a Delaware pre-pack. We were lucky. We had a parent holding company that had a lot of the long-term debt, and we knew that if we could convince the creditors to work with us, we could fix the parent holding company debt and restructure it at the operating company level at the same time. It was important that we were able to keep the operating companies out of Chapter 11. How do you do that? So in this particular case, in the span of just a few weeks, we got all the various creditor groups together, and we explained to them the downside of insolvency proceedings in Russia and Poland, Hungary, and the Ukraine. That was pretty easy for them to figure out. Those were going to be liquidations, and they would get very little value. And then we talked to them about how we could get a pre-pack done in the U.S., and we were able to do what we normally do. And one of the things we always do in restructuring, and here's the way to think about a pre-pack. There's really two simple calculations that you need to make when you're doing a restructuring. First, you figure out, you look at the business and say, how much debt can we really service? Then you look at it and say, okay, what's the total enterprise value of the business? Once you've figured out those two concepts, it's then pretty easy to look at the balance sheet and say, okay, I know how much debt I can preserve. I know what debt has to be restructured. I know what debt has to get converted to equity. And I know where the value runs out and which equity or debt has to get wiped out. And you do that all the time, whether you're negotiating an out-of-court restructuring or a pre-pack, and that's what we did in CEDC. And in the process, we were able to get the senior secured creditors to agree to take some discount. I think they ended up with about 85%, 85 cents on the dollar. And then we got the most junior secured creditors to consensually agree to take a 30 cents on the dollar. Again, what they do is they look at what they could otherwise get in an insolvency proceeding, and we were able to convince them that this was better than the alternative. And it was important that we got that, because the only way to save this particular business was to remove the guarantees all at the operating level that they had, and the only way to do that was to get over 90% of the bondholders to actually vote in favor of it. So we used this process to convince people to do that, and then we brought this to the Delaware Bankruptcy Court, and Judge Sanchi was good enough to confirm this in about 33 days, and we were able to move through the process. We received the usual objections that said, shouldn't file in the U.S., bad faith, we didn't have the right process, but Judge Sanchi looked at it and said, no, what we did here was consistent with the intention of the Bankruptcy Code, it was consistent with the policies behind it, and frankly, the procedure we went through, he said, was beyond reproach. So that's one example of consensus building and how you preserve value. Now, you can't always do this on and sometimes you're able to do this completely on an out-of-court basis, because one of the things to remember is that once you're able to convince parties that you can make it binding on them in a pre-pack, you're often able to convince them to work with you on an out-of-court basis. That's one of the beautiful things about pre-packs, is that sometimes you can use it to restructure businesses without ever having to go into Chapter 11. Once they understand that you can bind them in a pre-pack, there's often no need to do that. And we do that, we've done that for a lot of companies over the years. And that's why a lot of the companies we restructure actually never go into Chapter 11, and people often don't even hear about them. Now, sometimes you don't have the ability to do a pre-pack or to do an out-of-court restructuring, but you can still build consensus. And AMR is a perfect example. You know, AMR is the parent company for American Airlines, and it had filed for Chapter 11. Walgatchel represented the debtor, Skadden represented the Unsecured Creditors Committee. And in that case, you know, it was an interesting situation. Clearly, the company went in with a definite strategy in mind. They had publicly stated that they wanted to reject the labor agreements and the pension agreements, and then they'd come out on a standalone basis. And that's certainly a fine way to proceed. It's a good process. It makes sense. But in representing the creditors committee, we and the other advisors looked at it and said, you know, we should consider all options, not just the debt side, but also the revenue side. We knew that there were other airlines interested in a potential merger, like US Air, and we said, why don't we look at least the possibility of maybe doing a merger while in Chapter 11, even though it's never been done before in the airline industry, to see if that was a way to maximize value. And the key here, again, was trying to build consensus. The first thing we had to do amongst our committee was try to build a consensus. And frankly, that may have been the most difficult part. We had 9 members to the creditors committee in AMR. I had 3 labor unions, 3 indenture trustees, the PBGC, and 2 trade creditors. They couldn't have had more disparate views at the beginning of the case. There wasn't any trust. They didn't really like each other. But we convinced them that if we could build consensus within our room and not get into a war with the debtor, we'd have a better chance of having a reasonable business conversation, developing a consensus on a plan that would maximize value and make this a great airline coming out. And ultimately, that's what we ended up accomplishing here. We built a consensus within the committee, and then we worked very closely with Weil and Latham and the other professionals in this case to try to build a consensus. And in the end, it became clear that the synergies between the 2 airlines made so much sense and created so much value that we all worked together to make that happen. So that's a good example of, again, of consensus building as opposed to litigation. I think we're proud to say that in that case, the creditors committee never opposed a single motion by the debtor in the bankruptcy court. We preferred to work behind the scenes and try to develop a consensus on all issues, and we were able to do that thanks to very collegial professionalism by all the attorneys. Okay, so let's talk about what happens when you can't achieve consensus. You end up in Chapter 11 for a much longer period of time. Restructurings can be much more costly. The returns to stakeholders can be a lot less, and there can be a very significant impact on the company. Here are some examples. Now, let me take a step back. This is a very simple chart, and it's apples and oranges. Obviously, when you're doing a pre-pack, there's some costs that occur before you file. It's not included in here. But the idea is it gives a sense of the difference in cost, the length of time you're in Chapter 11. Now, this chart shows the cost of CEDC, AMR, and Lehman. Now, let me be crystal clear. Lehman Brothers is an exceptional case. It was the largest case ever done, probably the most complicated. You couldn't have avoided a free-fall Chapter 11. The government just foisted it upon the company at the last second. The professionals in this case, again, it was Weil, they did an exceptional job, so this is not meant as a criticism. The chart, however, does show the difference in cost for the length of time in Chapter 11. And what it shows is that when you're in Chapter 11 for a relatively short period of time, the costs can be very small. CEDC was about $12 million. AMR, which was more of a traditional, but one in which we move quickly towards a consensus-building process, another very successful case, which resulted in the single largest airline coming out of the Chapter 11 case, was more, but let me find the numbers to make sure I get them right. So for AMR, it looks like the total costs were about $235 million for that process. Another successful result, but obviously a higher cost because we were in Chapter 11 for a period of time. And Lehman Brothers, which is at the far end of the spectrum, obviously the most expensive because it was the most complicated, but it was in for a significant period of time where you weren't able to really build a consensus because you didn't have the time to do any preparation for that. That was about $1 billion in cost. So I think it gives you a sense of the value that can be created by building consensus, and I think it's something we continue to strive for. And with that, I'll open it up for any questions or turn it back to the panel.
Thank you, Mr. Goffman. So we have some time for questions now.
Thank you very much. I have a question regarding the information that is offered to the debtors in the Chapter 11 and in the pre-pack. We have a problem in Israel that there is a different information that actually the debtor in possession has, and that's, in a way, he's much more powerful to negotiate with the creditors than the creditors themselves, the market, if it's not a company traded on the stock exchange. And even if it's a company traded on the stock exchange, still the information is different than the debtor in possession has or the secured creditors. So my question is, how do you deal with the Chapter 11 and with the pre-pack on the question regarding information? Thank you.
Yes, the disparity of information is always a question and an issue when you're trying to negotiate, whether it's a pre-pack or what we also call a pre-arranged. You negotiate everything and then handle the vote in a Chapter 11 or even in the Chapter 11. Particularly since you have different groups of creditors who form ad hoc committees. I won't talk for a minute about an official committee because they typically will have an immediate arrangement on dealing with confidential information. So you really need to as the debtor counsel and professionals, you need to find a group within an ad hoc or several ad hoc committees of creditors who are willing to become restricted. And we enter into non-disclosure agreements. Thank you, Judge. To become restricted means that you would enter into a non-disclosure or confidentiality agreement so that, one, you would be able to get material, non-public information from the company, but by the same token, you are agreeing to be restricted in the context of trading securities. So you can imagine when you're dealing particularly with hedge funds who own debt, that this is a potential problem for them because they do not necessarily wish to restrict themselves from trading. As a discussion goes on, there may be several members of the group who are willing to do that. One of the troubling issues that I see in our cases is that the entire group does not want to become restricted, does not want to sign the confidentiality agreement, and hopes that their professionals can take on that responsibility. I think it's a difficult task for the professionals to work with their clients in that context, but you do see those arrangements in terms of lawyers and financial professionals taking in all the information, working to a point, maybe bring one or two members on who agree to the confidentiality, and then it opens up when you're closer to a deal.
Thank you. I agree with what Marcia said. I think I'd start with the proposition that when you're in Chapter 11, there's free flow of information. You have to advise your clients that once you go into Chapter 11, it's like a fishbowl, and you should assume that much of your information is going to be out there in the public. Trade secrets you can still keep secret, but much of the other information is going to be out there. The hardest part is exactly what Marcia described, is when you're in the pre-filing period and you're trying to negotiate whether it's a pre-pack or a pre-arranged plan, is sitting down and getting parties to take that information so that you can really negotiate with them. And the issue is, while some parties will get restricted, the battle is over how long the restriction will be, And then what information do you have to make public? Because the requirement's always going to be, will be restricted for a period of time, but on a date certain, you, the debtor, have to agree to take this information and make it public, usually by filing with the SEC, or we, the creditors, are permitted to do that. And then there's a whole negotiation over what that time period is and what information you have to make public and what you don't. Now, the problem is, as Marcia said, there's a slew of information that is important to creditors in making those decisions, information about business plans and projections, that debtors often don't want to make public at any time. So you end up with this concept when you negotiate these non-disclosure agreements where there's certain information you deem confidential, and the parties that sign confidentiality agreements can get them and get access to it, and you agree to make that public at a date certain. And then there's a higher level of information, what you call the highly confidential information, which only goes to the professionals for these committees. And that information, they're not allowed to pass on to their constituents, and you don't have to make that public. It makes for a very awkward process in the negotiation, but it's one of the things you have to do as you go through a pre-pack or prearranged process.
It applies even during the bankruptcy case. My colleague, Judge Peck, who you'll be hearing from, served as the mediator in a very large case that I've had, the residential capital case. The committee, there are always bylaws and they always get the information, but it's very difficult to reach consensus without the principles of the major creditor groups being involved in the negotiations. Because of this issue about becoming restricted, to the extent that those creditors are prepared to establish an ethical screen so that the people involved in the negotiations can receive the information but cannot participate in trading decisions, that's quite doable. It's when they're not prepared to do that, when they insist that they're not prepared to become restricted or are prepared to become restricted for a very short time, that it becomes an issue. And there's variation in the bankruptcy courts in the US. There was a decision now withdrawn in the very well-known Washington Mutual case in Delaware. It created a great deal of consternation among the private equity distressed debt community because of making those holders temporary insiders, and when they receive confidential information, presenting major problems for them. In residential capital, Judge Peck is the mediator. Ultimately, an order was entered. Initially, they presented an order that I was not prepared to sign. With Judge Peck's help, they modified that order, and there was another order that was entered ultimately. It did have a so-called blowout provision in that after a period of time, the information would be made public. Information also can become stale, so the longer the case goes on, and depending on whether it's a reorganization or a liquidation, certain information no longer has the same importance. But it's a very difficult issue when you're trying to deal with large creditor constituencies, when you really want the principals and not just their professionals involved.
I just wanted to add, and for the panel to go on it if they want to. The issue is not, as I understand it, only in negotiation. It also occurs when a 363 sale is planned. So very many Chapter 11 cases now are forms for auctions. And there is an issue of getting information to potential bidders. And the restrictions do apply in those cases, and this is where I'm at the end of my expertise. And similar issues to the ones you've all discussed, and again, correct me if I'm wrong, arise as well.
Any more questions?
Wouldn't exactly that issue be resolved by appointing a trustee or some external person who would be in charge of revealing and getting all that information, that is, some of it is confidential or not, and determining what should be presented to the creditors and what should be withheld from the creditors? What you're saying, in essence, is that you're leaving it to the debtor to determine where and how he reveals or discloses information. And at least from our point of view here in Israel, I think the advantage of having someone who is external, is not involved and doesn't have a vested interest in the company, can manage it better and come to a pre-pack or to a prearranged agreement better than the debtors would, as I would see it.
Well, I think, let me just react to that. Once you have a trustee, certainly in the United States, you're in bankruptcy, and as Jay Goffman pointed out, the information is going to be more free-flowing in any event. Not entirely so, because we still do have questions of confidential information during the Chapter 11 case. I think that it would not be that well received, I think, in the creditor community in the first instance, because there is no debtor community. You're not a debtor until some disaster happens. But I think that in the creditor community, I'm not sure how well received that would be. I think there is some comfort in negotiating the terms under which you receive the information, negotiating the length of period that the information would be held confidential. But of course, the other side of that is they might get more information if there is an independent body. But there won't be one outside of bankruptcy. And I think that's, not going to solve the problem of pre-bankruptcy negotiations.
Yeah, I actually don't think that the issue is the debtor making the decision as to how much information to disclose. That's not a big deal. The debtor understands there's a lot of information it has to give out, and it's prepared to do that. The question is, from the creditor perspective, the creditors don't want to get access to confidential, non-public information, because when they have that, then they're not permitted to trade in the securities. So they're the parties that are saying, no, keep that away from us. We don't want that. You can give some of it to the professionals. And frankly, when you look at the entire creditor body, the creditor body as a whole wouldn't want a company to be disclosing trade secrets or other important business information that could harm the business, because that would just destroy value. So I think, at least in the US, the problem isn't whether or not the debtor is willing to disclose information. The debtor is. The problem is that the trade creditors, the creditors that you want to negotiate with, are unwilling to take that information and keep it for an extended period of time because it limits their ability to trade in the debt.
Hi, guys. I'd like to actually, and I'm one of the panelists, but I'd like to find, because there's a little bit of a missing translation here. The issues that is really being raised here is not an issue of an ability to trade. The questions are geared towards the asymmetry of information that exists, within the Israeli insolvency practices when creditors are negotiating with the companies and the sponsors. And I think to these questions, the answer is a practical answer. In order for creditors to be prepared to negotiate a restructuring with debtors and sponsors in the United States, they demand, through professionals or directly, depending on their comfort level, access to financial information without which they are not prepared to enter into consensual restructuring arrangements. And so information is necessary and oftentimes a condition to entering into a deal. That is the practical, answer to your question. Yes. Sorry.
So where our bankruptcy code in section 1104 provides for the establishment of creditors committees, and the U.S. trustee, when a case is filed, a Chapter 11 case, solicits interest of the largest unsecured creditors, and if there's interest, forms a creditors committee. And that committee typically very quickly adopts a set of bylaws that deal with confidentiality of information it receives. And it insists on obtaining material, non-public information to assist the creditors committee in any negotiations. And if it feels it's not getting it, we hear about it. We, the judges, hear about that very quickly, and we're able to require that that information be shared. The quid pro quo is when the committee receives it, it is subject to various non-disclosure requirements, but it's intended that the creditors committee acting for the unsecured creditors will go ahead and attempt to negotiate. And to be able to do that, it needs to make sure that there's a level playing field, that it has the information that's required. Secured creditors, usually are able to take care of themselves. Usually the secured credit agreements have in it provisions with respect to disclosure of internal information.
The only one caveat to that is that even in Chapter 11 cases, the secured debt becomes more widely held than the original holders who were party to that confidentiality agreement. And you'll frequently have a group who are bound by the confidentiality and some who are still trading and decline to take the material non-public information. But that's by their own choice. As long as there's a group with which you can negotiate, that will work as a practical matter during the Chapter 11 case.
The truth is, for people that represent companies in restructuring, I think all of us would disclose as much information as we could if there was any way to lock the creditors into the process. The problem is a lot of times creditors want information for a short period of time and then want it blown out so that they can trade out of the position. I would give up access to information in exchange for locking those creditor parties in during the case so you can get to the negotiated solution every day of the week.
Okay, we don't have time for any more questions. I'm sorry. So thank you very much, all panel members.